Ms. Hayes-Suhon, we would be particularly assisted if in your submissions you could focus upon the following matters. We're not trying to stop you going elsewhere. Firstly, what learning in the rules or practice directions or elsewhere there is about the circumstances that justify moving from prescribed, or as the case may be, fixed costs to assessed costs. And secondly, what there is beyond that reference in the practice direction which we looked at this morning to assess costs being on a standard or indemnity basis, and whether you're submitting that the judge's order in this case was on one or other, and if so, which of those bases?
Yes, please, my lord. My lord, the first question that you asked, I believe,
I'm afraid you're very, very quiet. Is it possible for you or someone at your end to turn up your volume? We may be able to do it at this end.
They are in this dip, the volume of speaker.
My lord, this morning they were required to turn up the volume on your end. I know that I have signed back on a different link, so I'm not sure if they also need to turn up the volume again on your side, or if this is now better.
You're loud and clear now, thank you.
My lord, before the lunch break, I took my lords to the evidence, which I call the battlefield. I do intend to answer my lord's questions very shortly, but if I could just finish this one point on whether the appeal was a genuine, bona fide appeal on the merits. I just want to quickly finish this point. My lords, I will take you, my lords, to the transcript of the oral decision, page 7 of the bundle. And I just want to quickly take you to line 8, where in her oral decision, the judge stated that the strongest evidence was, of course, the actual documentary evidence of copied ID cards, bearing out that Mrs. Alwari was careful to obtain and copy the ID cards and to keep the copies on file. The claimants were both confronted with the copies of their IDs. Mr. Rampersad, in particular, said that he kept his ID card at all times and never lost it nor lent it to the first defendant. The claimants were also confronted with a copy of the check made in their favor by order of the first defendant. And my point here, my lords, is simply that all of these reasons, the evidence, the documentary evidence, the oral evidence, they were all available to the appellant when the appellant filed its notice of appeal, their notice of appeal. And my lords, similarly, in the judge's written reasons, which came after the notice of appeal was filed, my lords, if I can quickly take you to page 19 of the bundle. The judge in her written reasons again stated at paragraph 28 that the strongest evidence was, of course, the actual documentary evidence of the copied ID cards. And the fact that the appellants had no explanation as to how the attorney got copies of their ID card if they never went to her office. And so, my lords, we say with respect to the genuine, whether this appeal was bona fide, whether it was a genuine appeal on the merits, we say it is clear that the appellants fabricated this entire matter from the very beginning. And therefore, any appeal on the facts of this case cannot be genuine. The notice of appeal had no grounds on any points of law. The only ground of appeal had to do with the facts of the case, that the decision went against the evidence, not on any points of law. And that takes me to the second point, which is the judge has fallen into an error on a point of law which governs or affects costs. And my lords, if you review the James Yeo Privy Council matter, in that matter, the Privy Council actually found that there was a defense raised, a defense was properly pleaded, that the judge did not properly take into account. And that can be found at page 768. Their lordships, therefore, of the opinion that the defense admitted under the general traverse and established by Mr. Yeo's evidence should have been followed by the legal result as to costs. So in that case, there was actually an error on a point of law which governed or affected costs. And my lords, I wish to take you very quickly to the Bolai Court of Appeal decision, which is at page 672 in the bundle. And my lords, I take you to this case because it deals with the point of law. When an appeal is on a point of law. And it is to be noted that in this case, in the Bolai case, that the Court of Appeal came to the conclusion that where you appeal the assessment of damages, that is not even on a point of law that governs or affects costs. And therefore, leave was required. And if I can take you, my lords, to the page 672. My apologies, my lord. Page 676. From G. I come now to the last question, the question of costs. My first observation is that the appeal is not one from the whole of the judgment or any issue relating to merits, but from so much of the judgment only as relates to the quantum of the damages awarded and to the judge's refusal of any order as to cost. And my lords, I draw this to your attention because what is required is that there must be, the judge must have fallen into an error on a point of law which governs or affects costs. And we respectfully submit that there is no point of law that was raised in the notice of appeal that would govern or affect costs. And therefore, as the appeal was not a genuine bona fide appeal, and as the appeal was not on any point of law which governs or affects costs, we say that leave was required. Now, my lord started off by asking, I believe, if there was anything in the CPR rules in terms of moving away from prescribed costs. And I would say this, my lord. I would take you quickly, my lord, to Rule 66.6 of the CPR, which can be found at page 633.
633, did you say?
Yes, please, my lord.
Thank you.
And I wish to make the point that the CPR does not in any way take away the discretion of a judge in awarding costs, but gives guidelines as to the appropriate orders for costs. And if I can take you to 66.6(4), it says, in deciding who should be liable to pay costs, the court must have regard to all the circumstances. And then in 66.5, it says, in particular, it must have regard to the conduct of the parties, that's A, and C, whether it was reasonable for a party to pursue a particular allegation and or to raise a particular issue, and D, the manner in which a party has pursued his case, a particular allegation, or a particular issue. And of course, my lords, we have submitted in our submissions that this is a case that was based in fraud. The particular allegation was one based in fraud, and therefore the usual cost order in a matter based in fraud would be assessed.
Could I interrupt you for a moment? Sorry. This rule, as I understand it, is dealing with liability to pay costs, not with the way in which costs are going to be assessed. There's no doubt that the judge, it's not disputed that the judge was entitled to order the claimants to pay costs, which is what this rule is concerned with. The question is, when can the judge order costs to be assessed rather than quantified on the prescribed basis? And this rule, as far as I can see, is not addressing that. It's dealing with liability for costs.
My lord, I say that this rule gives guidance on the type of cost, the amount of cost that are to be paid. So, my lord, if you look at D, it says...
Sorry to interrupt you. Why do you say that? Because it's dealing with when a party is going to be ordered to pay costs. It's not dealing with how do you decide what amount that costs order will represent. It's not dealing with that at all, is it here?
Yes, please, my lord. In my respectful view, it does deal with the amount that the court can award in terms of cost, because you're looking at the conduct of the parties, etc.
But that's all in deciding who should be liable to pay costs in full.
This would be after the court has determined who was the successful party.
Yes, but it's dealing with who is going to be liable to pay costs, not with what costs they will be liable to pay if they are ordered to pay costs.
Well, the rules don't specify that you must apply prescribed or assessed. It's all in the discretion of the court. What the rules
where is that dealt with? You say it's here. Is this where you say it's dealt with?
Pardon, please, my lord?
Is this where you say that discretion arises, or is there any other rule?
My lord, part 67. My lord, I will come back to that question as soon as I have found the exact rule.
Yes, you might.
But I do wish to make the point that in determining whether it is prescribed or assessed, as my learned senior has acknowledged, it's all in the discretion of the court.
You may get some help from 67.2 sub 3, read having got yourself into context by looking at 1 and 2, page 6, 3, 5 and 6, where conduct.
Yes, please, my lord. It
comes in
is
on
67.23.
Deciding what it's reasonable to order a party to pay.
Yes, please. And there again, my lords, you would see in 3B the conduct of the parties before as well as during the proceedings.
Yeah.
The importance of the matter, the time reasonably spent on the case, in which case this was a 4-day trial with 2 handwriting experts. So, my lord, we do say that the rules, the cost remains in the discretion of the judge. And my lords, I want to address you on the point of whether the appellants ever made an application for leave. Because my learned senior spent a lot of time saying, well, once you have a reasonable prospect of success, which we say they don't even pass that hurdle, but before you even reach the stage where you consider whether they have a reasonable prospect of success, an application ought to have been made. And my lords, in that respect, I wish to take you to the Court of Appeal transcript. I know my learned senior took you to it, but I wish to take you to page 33. Line 40. where Mr. Pariag Singh before the court said, my lady, I could have also applied for permission for leave to appeal on the issue of cost only. The fact remains that the appellants never applied for leave to pursue the issue of cost only, even after receiving the respondent submissions where we took the preliminary point. Their submission has always been that their appeal was a genuine one on the merits, and therefore leave was not required. And my lords, as was seen in the Bolai case, even where the court is of the opinion that it would not have made that order for costs, the Court of Appeal in Bolai said that is irrelevant if we disagree with the order if leave was not granted. So whether or not the Court of Appeal acknowledged in the transcripts in their judgment that the order seems to be wrong, and I say that with the understanding that we did not have the learned judge's oral transcript, that decision, before the Court of Appeal or the conditional leave judges. Our submission on that point is that it's irrelevant whether the Court of Appeal found that the order looked as though it was not correct, because without leave, the Court of Appeal had no jurisdiction. And respectfully, we do not believe that the appellants could come at this stage and say, well, the Court of Appeal could have granted us leave at the substantive hearing, when firstly, there was no application for leave to be granted in the first place. And my lords, I want to quickly take you to the supplemental bundle filed by my learned senior last night. And I first take you to the Gulfview medical decision, paragraph 22. And I think it's important for me to address my lords on this concurrent jurisdiction of the Court of Appeal under Section 38. And I first take you to this decision, paragraph 2 of the Gulfview, where it says the main factor to consider in determining the grant of leave is whether the application has a realistic prospect of success. Paragraph 23, the determination of whether a case has a realistic prospect of success is a preliminary assessment that is made before full argument and consideration of the case. So even if a party is seeking leave from the Court of Appeal, that leave is not to be done at the substantive hearing of the appeal, but is to be done prior to the substantive hearing, before the full arguments and consideration of the case. And this is what the rules and the section contemplate. If I can take you to page 55, which is part 64 of the CPR. And I am taking you, my lords, to page 56 of the supplemental bundle. 64.2, rule 64.2, where an appeal may be made only with leave of the judge making the order or the court, a party wishing to appeal must apply for leave within 14 days of the order against which leave to appeal is sought. The application for leave to appeal must set out concisely the grounds of the appeal. And my lords, if I can take you in that same part 64 to page 58, part 64.5, it says the notice of appeal for procedural appeals is 7 days. In the case of any other appeal, it's 42 days. And so, my lords, we make the point that if the jurisdiction of the Court of Appeal is to be invoked, that jurisdiction would need to be invoked by an appellant who has filed his notice of appeal within 14 days and has also made an application to the Court of Appeal for leave to appeal on costs. And my lord, there's just one further section, 64.14, on page 62, that says any application to the court must be made in accordance with Part 11 and must be heard in the first instance by a single judge. And so our simple submission is that in accordance with Part 64, any application for leave to appeal costs must firstly be made within 14 days and also must be made in accordance with Part 11. And we all know that Part 11 requires an application to be made in writing. And so, my lords, this point is not new. Our Court of Appeal has set down the procedure to be followed where a party wishes to appeal on costs. And this was in the Court of Appeal decision of Wazir Mohammed, which can be found on page 952 of the bundle. And in Wazir Mohammed, the Court of Appeal made it clear that a party wishing to appeal on the issue of costs should first apply for leave from the registrar or judge or master making that order. So there's no uncertainty as to the law or to the procedure to be followed in terms of seeking leave to apply an order for costs. The Court of Appeal has already clearly stated in the Wazir Mohammed the procedure to be followed. The CPR also has it clearly stated. The appellants have not followed those procedures. And the appellants have not followed the procedure in terms of after they received the written judgment, which closely mirrored the oral judgment, they did not even seek to amend their notice of appeal to include, well, the judge should not have made an order for prescribed costs. Assessed costs, sorry. And I do wish to make the point, my lords, that even in the notice of appeal, one obvious ground of appeal in terms of fact finding would be that the judge found that the appellants signed the deed, executed the deed. So we say, my lords, that there is no genuine, the appeal was not one that can be determined or can be called genuine. And my lords, we say that there was no point of law which governed or affected costs. We say that cost remains in the discretion of the trial judge. And we say that from the facts and from the reasoning of the trial judge, from the battlefield in this trial, it is obvious that the judge ordered assessed costs having regard to the nature of the matter as well as to the conduct of the appellants who was shamelessly lying on oath. My lords, with regard to the assessed cost, whether it's on the standard basis or the indemnity basis, my lord, I do not agree with my learned senior counsel, my learned senior, that the registrar does not have the power. My lord, when the statement, assessed cost means that the respondents would file their statement of costs. When the statement of costs reaches before the registrar or the assistant registrar would then determine whether certain items would be allowed or not. The registrar would look at the order made by the judge and determine whether items are being allowed or not being allowed. But it is clear from the order that the judge made an order for assessed costs. And what would be included would be in the discretion of the registrar when taxing the statement of costs.
But that doesn't give the registrar the power, does it, to decide that it should be on the indemnity basis? That's not something a costs judge could really take a view about. That's part of the, if it's going to be made at all, surely it has to be part of what the trial judge thinks appropriate, having heard the trial and considered the conduct of the parties and all the other things you showed us.
I agree, please, my lord. And in circumstances like that, the registrar may contact the judge, write to the judge, and seek clarification. That is normally done, please, my lord.
Well, what basis? You say that's normally done, but what clarification could the judge give? The judge can't now make a different order from the one that was made, and either it says indemnity on the indemnity basis or it doesn't, and in this case it doesn't.
Correct, please, my lord. And our submission was never that the costs that were awarded was on the indemnity basis. Our submission was simply that the nature of the matter, meaning allegations made in fraud, normally carry an assessed cost on an indemnity basis. Now, when you look at the transcript,
are you saying the judge would have been entitled to order the costs on an indemnity basis, although she didn't, in fact? Is that the point you're making?
Correct, please, my lord. It was open to the judge, having regard to the nature of the matter and the conduct of the parties, to award costs either on the indemnity basis or on the standard basis.
And if nothing is said, is that the same as in this country, that it's taken to be standard unless it says otherwise? Well,
my lord, the usual practice is that if the order just says normal assessed cost, it means the standard basis.
Thank you.
It may not make a lot of difference in practice if the court is otherwise with you, because in assessing the costs on a normal basis, the registrar may consider that most, if not all, of these costs are reasonably incurred. But commonly, the difference, such as it is, arises where it is the issue in relation to any particular item of cost turns on the balance of proof. But in the context of a fraud case, ultimately, it may not make much difference.
Well, your practice direction on page 660, paragraphs 6 and 7, I think prescribes exactly the same, because it simply reverses the burden of proof as to whether costs were or weren't reasonably incurred or reasonable in amount, and removes the proportionality test if costs have been ordered to be paid on the indemnity basis. I think that's right.
Yes, please, my lord. That is what is contained in the practice direction. And my lord, I'm just looking at the transcript of the trial judge, and when she made her order, although it's not reflected in the written order, my lords, what she said, if I can just have a moment, please, my lords. One second, please, my lords. My apologies to the court. The claimants are to pay, on page 7 from line 31, the claimants are to pay the defendants the cost of and associated with this action to be quantified by the registrar of the Supreme Court.
Can I just take you back to a submission you made earlier on, which is about the discretion that you say a trial judge has. So as I understood it, the case being put against you is that this is not an open discretion, that the rules lay down a general rule that in this case would lead to prescribed costs, and that there's no justification for moving away from that. Now, you said in your submission, it's all just a matter of discretion. But if you look at the CPR rules, so if I take you to page 635, 67.2 starts off where the court has any discretion, which would not imply, or would rather contradict the idea that this is all a matter of discretion. Similarly, if you go to page 637, that's 67.3b small 3, where neither prescribed nor budgeted costs are applicable by assessment in accordance with other rules, which would, on the face of it, look as if it's a scheme that says there are general rules, but sometimes one can depart. Clearly, if it's a general rule, one must be able to depart sometimes. But the question I would want to ask is, first of all, that seems to contradict your submission that it's all a matter of discretion. But secondly, can you give us any help as to whether there's anything in Trinidad and Tobago that has explored or looked at this question as to when you might depart from the general rules?
Yes, please, my lord. With respect to the first question raised, I would say that there are a number of authorities that confirm that costs remain in the discretion of the judge. And with respect to whether it is prescribed or assessed, we say that that would be determined on the particular facts of each case. So the general rule will be applied. However, where there is conduct or where there's a particular nature of a case that requires some other consideration of costs, that remains in the discretion of the judge. So as my lord correctly said, it is the general rule. And when we look at this matter, we have to bear in mind the specific facts of this case, where the appellant's conduct, they were found to be shamelessly lying on oath. And it was also a matter where...
Sorry to interrupt, but have you any authority that you can help us with on that proposition that you've just put forward? You just said, yes, well, there's a general rule, but there's also discretionary exceptions. Is there anything to help us on the position since these rules came into place, into force?
My lord, if I may just have one moment, I wish to take you to the Court of Appeal decision. If I have one moment just to find the page. My lord, I first take you, there are two decisions that I wish to take you to. The first would be the decision of Justice Mohammed in the Elahi case, which is tab 14. It starts at page 897. And I'm taking you, my lords, to page 916. And my lords, you would see there at paragraph 46 that the judge, in determining the order to be made with regard to costs, said it is clear that the claimant's conduct prompted the defendants to apply for and proffer the application for a cost budget. And taking into account, therefore, all the circumstances of the case, and in particular, the the factors mentioned in part 66.6, I find it just to order that there be no orders to costs. I know it's not exactly on the point of whether you can move away from prescribed to assessed, but I am using this paragraph to show that it is always in the discretion of the court having regard to the conduct of the parties. And my lords, I also take you to page 485. My lords, that is a wrong, not that page. 1 minute, please, my lords. The Kumar Mahabir decision, please, my lords. Page 769. It's tab 10.
So what page? Could you give the page again? I'm sorry.
769 is the...
Page 799 is the Kumar Mahabir decision.
I thought you said 769.
769 is the case. Oh, 799 is the...
That's it.
And I take you, my lord, to paragraph 65, where the court in this matter acknowledged that it is therefore appropriate to consider whether any further guidance is provided by the rules themselves in exercising this discretion. To this extent, it is noted that the court, in exercising its wide discretion in determining who would be liable to pay costs and in what amount, does so against the backdrop of parts 66 and 67. And my lords, a few moments ago, we went through part 67, which allowed the court to take into consideration the conduct of the parties. And my lord, there's one further case, if I can just have a moment, that I wish to bring to your attention on this point. And that case says that the prescribed regime was not meant to be inflexible. My lord, if I could just have one moment to find the correct page. Para 73, page 893, please, my lords. It's the case of Trinidad. And I refer you to para 73. The Caribbean Civil Court Practice 2011 edition notes that there are cases where costs assessed or fixed by reference to the low amount of the value do not justly reflect the considerable complications of law or fact. In Donald and the AG Grenada, it was pointed out that the rules do not intend that the prescribed cost regime should inflexibly be applied in order to determine the costs payable. And so, my lords, I hope that these cases that I have pointed to, especially this paragraph, and this is a Court of Appeal decision in Trinidad, where it is acknowledged that the prescribed regime is not meant to be inflexibly applied, and that the court can take into consideration other factors as outlined in paragraphs 66 and 67, and of course, bearing in mind the Part 1 overriding objectives.
I think what's said against you again is looking at paragraph 75 on page 894, that in the general case at any rate, if a judge is going to depart from the normal guidelines, the general guidelines and the normal procedure, then the judge ought to give reasons. And a consequence of a failure to give reasons may be to require the Court of Appeal to set the costs order made aside and start again. So it's a matter for the assessment by the Court of Appeal as to whether or not the judge has fallen into error in such a way, presumably, as to create a risk of a miscarriage of justice. Is that right?
Yes, please, my lord. And I say that it's not, I make two submissions on this point that my lord has raised. One would be that the parties were allowed, after the trial of the matter, to file full written submissions in which they had the opportunity, as we do in Trinidad and Tobago, to address the court on the issue of costs. So after the trial was completed, the parties did have the opportunity to file full written submissions, and that is contained in the learned judge's written reasons. I can take you to it if necessary.
Well, were submissions filed in this case?
Written submissions were filed, my lord. I can take you to them. They're not before you, but I can take you to the judgment where the court says written submissions were filed, and I believe even reply submissions. Page 11, please, my lords. That is the reasons of the judge, and I will find the paragraph for you.
Did your submission say anything about costs? Did your written submissions say anything about costs?
My lord, I did not. I was not counsel in the High Court matter, please, my lord.
Okay.
I do not have a copy of the High Court submissions. I'm not sure if they're in the record of appeal. But my lord, at paragraph 6 on page 14, you would see where written submissions in the footnote 2. Written submissions were filed on behalf of the first, second, and third defendants on the 25th of May. On behalf of the fourth defendants on the 27th of May. The claimant's written submissions were filed on the 14th of July. On the 15th of August, submissions in reply were filed. And this was after
closing submissions at the trial on the merits rather than submissions after judgment, or was it submissions after judgment?
My lord, rarely in Trinidad and Tobago do we have submissions after judgment. These were the submissions after trial,
yeah,
which
well, you don't
normally
address costs, do you? At least in this country, when you make your submissions at the end of the hearing, it may be different, but we don't normally make submissions on costs at that stage. You wait till you see what the outcome is, and then you make your submissions on costs.
My lord, in this jurisdiction, when we file submissions after trial, we do make submissions on costs.
All right.
They are included once we file submissions after trial, and my learned senior can confirm that in his reply. But submissions by attorneys that are made after the trial of the matter do include submissions, usually do include submissions on costs.
And is it normal for a judge to decide costs without hearing any oral argument when the judgment's handed, or any further argument after the judgment is handed down? Because you might have thought that the submissions might wish to take account of what the judge has actually decided.
It is usual, please, my lord, that once judgment is given, that it includes a cost order. Normally, there are no further submissions. Normally, usually in the Court of Appeal, they would ask for submissions on costs. But in the High Court, following a trial, the judgment usually includes the merits and an order for costs.
Would there be nothing?
And usually do not require further submissions.
But there would be nothing to prevent either side going back to the judge saying, could you please elaborate the reasons for this particular order?
That is correct, please, my lord. And that was not done in this case. And my lord, I do wish to make the point, because it was made in the Court of Appeal, that the notice of appeal again contained no grounds with regard to the order as to costs. So when it was forwarded to the learned judge for her to complete her written judgment, you would see that the learned judge's decision focused on the facts of the case, because that was the only ground in the notice of appeal. But I do not agree that the parties were not given a chance to address the court on the issue of costs. Even when you look at the transcript of the oral judgment, at that stage, the appellant's attorney had the opportunity to stand and say, "My lady, we wish to be heard further on the issue of costs." But they did not do so.
Well, it would have been helpful to know whether your clients had actually asked for the order that was made.
My lord, that is something I tried to confirm, but my lord, I was not, unfortunately, I was not in the High Court proceedings either.
Well, I know you
And
weren't,
so-
but somebody was representing your clients.
Yes,
Maybe-
please, my
maybe
lord,
even
but
the attorneys or solicitors were the same, wouldn't it?
none of the attorneys for my client remain the same, please, my lord. But what the difficulty in this matter, I did reach out to the other attorneys in the High Court, but the difficulty is that the number of years that passed since the initial High Court matter, please, my lord, caused some difficulty. My lord, these proceedings were not filed at a time where we had electronic filing, so everything was kept soft copy. The proceedings, it's over 10 years that my clients have been put in court, in litigation, because of the appellants shamelessly lying on oath saying that they did not execute a deed. It's been over 10 years of litigation.
And presumably the costs
And so,
haven't
my
been
lord, there
assessed
was a
yet.
difficulty.
Presumably the costs have not yet been assessed. Or have they?
No, please, my lord.
No.
The costs have not been assessed as yet. There was an appeal that needed to be ventilated. Only at the 11th hour did the appellant say they were not pursuing their substantive appeal. And then we are now here on the issue of costs and whether leave was required. And again, my lords, I say that there was no point of law which governed or affects costs, so leave was required. And even if the judge, the Court of Appeal, was of the opinion that a different order may have been required or should have been made, the appellants still require leave. My lords, I now just quickly, in terms of some of the authorities that the appellants have relied on, I just want to quickly make the point that a number of these authorities are unhelpful simply because either they do not deal with matters of fraud, they do not deal with situations where the conduct of the parties were one where one party was, literally shamelessly lying on oath. There's no other way I can put it. I know I've repeated myself, but that is what happened. So they are in the round very unhelpful. They deal with situations where should I make an application for budgeted cost before at the first CMC or before the trial of the matter? They do not deal with the situation where the judge, in her discretion, in dealing with allegations of fraud, and where, based on documentary evidence, it was found that the conduct of the parties was so shameless, in her judicial discretion, decided to award assessed costs. My lords, one moment, please. My lords, I do not wish to repeat myself. My learned senior made the point that the prescribed regime is there so that litigants can know exactly what is their cost implication in filing a matter. And I simply say that is for the usual litigant. But in this case, this is not a usual litigant. This is a litigant that fully well knew that they did execute the deed and chose to bring proceedings knowing that those proceedings and their allegations were completely false. And therefore, that takes this matter out of the usual proceedings where someone may have had an arguable case, but the judge simply did not agree with them at the end of the day. And in advising your client, it is well established that conduct, and we have put before the board the cases on fraud, that parties have no choice but to come and defend themselves, takes this case out of the usual, well, the litigant should know how much it cost. Well, you should also know that if you come and you shamelessly lie on oath, you will be liable to higher costs. And with regard to the Court of Appeals order of the 2/3 of the assessed cost below, we say that the cases we have submitted show that even in fraud cases, when you withdraw your matter at the 11th hour, you are still entitled to your full cost because of the nature of the fraud and the fact that the parties have no choice but to come and defend themselves. So we do not agree with the appellant's submission that a different order should have been made in the Court of Appeal. The respondents would have already incurred 4 years of legal fees. Preparation, this was in November for a trial that was taking place in February. And the appellants had the opportunity at the case management conference before the Court of Appeal to say, well, listen, we are not pursuing, but they did not do so. And they knew, we submit that the appellants very well knew that they had no genuine appeal because of the documentary evidence in this matter. They did not require the transcripts. So we also say that the Court of Appeal was right in making their 2/3 order. This is over 10 years of litigation because the appellants fabricated an entire story.
Is
The respondents are completely innocent.
Am I right that the 2/3 order is the normal order that would follow unless the Court of Appeal decide to do something different?
Correct, please, my lord. That is the usual order. And again, please, my lord, this is all based on whether the appellants even had jurisdiction to challenge the cost order in the first place. They still have that hurdle to surpass. And my lords, I wish to put it on the record, it is the respondents' attorneys that requested the transcript of the oral decision. And it was the respondents' attorneys that obtained the transcript of the oral decision and then forwarded that to the appellant's attorneys and requested that it be included in the record that is before the board. One moment, please, my lords. My lords, I do not wish to repeat my submissions, but I do wish, again, we have raised the, we have relied on the Dixon decision that where the conduct of a party or the pursuit of a hopeless claim may justify an order for assessed costs. Please, my lord. And we refer to that, that's at the page 689 to 690 of the bundle.
690?
689.
Yes, please, my lord. 689 of the bundle, and that's the Dixon decision.
That's Dixon and Radley House.
Yes, please, my lord. And it's at the top of page 690. The pursuit of a weak claim will not usually on its own justify an order for indemnity cost, provided that the claim was at least arguable. But the pursuit of a hopeless claim, or a claim which the party pursuing it should have realized was hopeless, may well lead to such an order. And we say in this case it is clear, my lords. It is clear.
Uh, 690.
Which paragraph are you in there, please?
C, I think.
It's the top of the page.
Top of 690.
It's C at the top.
Overnight, full circle, and AMEC. Which is course.
Yes. Oh, well, the Elvenite, yes.
So, my lords, we say it is well established that the conduct of a party, especially when one pursues a hopeless case for more than 10 years against innocent parties, we say that that clearly allows the court to exercise a discretion to award assessed costs.
Is there any authority of which you're aware that recognises that principle in the context of the, if I may say so, rather different costs regime that now prevails in Trinidad and Tobago compared with that which then and in fact still now prevails in England and Wales?
My lord, the authority that I would have shared with the court before, the Court of Appeal decision, where it was stated that the prescribed regime is not meant to be applied inflexibly. Please, my lords.
I understand that, yes. Thank you.
And we do have authorities, please, my lord, I believe from the Privy Council and the submissions that say cost remains in the discretion of the court in Trinidad and Tobago.
Could I ask this question? If we were to be with you and would dismiss the appeal, the consequences of that, as I understand it, is that the order stays as is for costs to be assessed by the registrar. Would that mean, and I'm going back to something you earlier said, that the assumption should be that that will just be assessment on the standard basis and not on the indemnity basis?
Yes, please, my lord. I would accept that it would be assessed on the standard basis, please, my lord.
Thank you.
Well, Ms. Hayes-Ruhon, does that complete what you want to say to us?
Yes, please, my lords. I don't think there's anything further I can add to my written submissions that are before the board. And I hope that I have satisfactorily answered all the questions that my lords have put to me. And if I can be of any further assistance, I am happy to answer any further questions that my lords may have.
No, well, thank you very much indeed. Yes.
My lord,
Mr. Ramlal.
my lord, my learned friend referred you to a case of Elahi, and it starts at page 897, and I'd like to take you to 914. This was where the judge was dealing with an application for a cost budget, and at paragraph 40 he says, look, in order for the court to consider an application for costs to be prescribed at a higher level, the defendant ought to have filed the appropriate application. Even such an application would have been misconceived for the very fact that the claim is not for a monetary sum. and therefore the value is not known. In this regard, the appropriate application to be made is to determine the value of the claim, which has no monetary value. I pause there. That is what should obtain in a case like this, where there is no monetary value attached to the claim. You make an application to the judge to determine the value of the claim where there is no monetary value. He says such an application will necessarily fix the value and thus prescribe the costs at an appropriate level. Where this is not done, then the party who wins the case is stuck with the provisions of Part 67.5(2) as amended, deeming the claim with no monetary value for $50,000. In fact, this is what should have been advanced before Rajkumar J. and the case management, etc. As it stands, the cost budget is dismissed, etc. So that encapsulates what the position is in Trinidad and Tobago.
Isn't the underlying policy, as I understand it, I think you showed us something this morning, is that parties should know exactly what they stand, where they stand, and what they're in for if they take the case to trial?
That's correct.
But does that apply to somebody who's bringing a fraudulent claim? Surely there, the interest in knowing where you stand is overridden by a public policy of not encouraging people who are fabricating a claim to be entitled to take it to trial on the understanding that they're only going to have to pay up peanuts amount of costs if they lose. There's no policy in promoting that, is there, or facilitating it?
Well, my Lord, there is no decided case on it, and I can see that as a matter of public policy, one can create exceptions. Yes, certainly. But my Lord, that reinforces the point made in Trinidad and Tobago, that if you're about to develop something to depart from the general rule as a matter of public policy, then what you ought to do is follow the procedure set forth in Trinidad and Tobago, identify it to the parties, ask, give them an opportunity to be heard, and then give a reasoned judgment on that. And that's not what happened. Can I answer my Lord President point about the departure between the UK and the Trinidad rules by taking to page 788, the Kumar Mahabir judgment? Because this is a fundamental distinction in the policy approach between the UK rules and the Trinidad rules. At paragraph 35, page 788, unlike the UK system, and deliberately so, neither the scheme of prescribed or budgeted costs in our CPR invites the court to embark upon any detailed assessment of costs actually incurred by the parties at the end of the trial. We are mindful of the deliberate choice in this jurisdiction by the framers of the rule to eliminate the days of long, drawn-out cost processes with unpredictable results and to create a more predictable regime of costs in Part 67 CPR. My Lord, the peculiar circumstances in our legal culture that gave rise to this change in our rules was to achieve, that was page 788, my Lord.
Thank you.
Paragraph 35.
It's paragraph 35.
What's the name of the case?
It's Kumar Mahabir. It's page 788. And I was reading from paragraph 35.
Yes, I've got it marked up.
Thank you.
So the short point is the imperative for Trinidad and Tobago in making these rules, having regard to what obtained in our legal culture, my lords, was to have predictability, consistency, and certainty. Now, the fact that it's a case where fraud is alleged doesn't necessarily take it outside of that, my lord.
Certainly where the fact that fraud is alleged, but here the complaint is not so much that fraud was alleged, but that fraud was alleged fraudulently.
To the extent that
and it's humorous, but it's actually, in a way, it's pretty serious, isn't it?
No, it is. I mean, to the extent that one can allege it honestly or fraudulently, it is. But, my lord, it brings me back to the point that to the extent that the judge, at the end of her judgment, comes to a finding, my lord is correct, that when the judgment on the liability is determined, and the issue of costs has to be now decided, the judge has to then give the parties an opportunity and let the parties know, well, this is my intent.
Well, what do you say about the practice we were told about? Do you have any, can you help with that? Because
the practice,
your opponent said that the practice is to deal with that in written submissions.
Well, my Lord, I've asked to see the written submissions. I am advised that there was no application by the defendants in this matter to depart from the usual order for costs. And that, in those circumstances, my Lord, that would make the order that the judge was proposing to make all the more a bit of an application.
So you say you're advised. Have you seen the written submission?
I have not, my Lord. I'm advised, but I have not seen it. But we will endeavour to get it, my Lord. But, my Lord.
Well, somebody's seen it, have they, to advise you of that?
Yes.
Somebody has them?
Well, they haven't shown me the submission, but they've indicated via WhatsApp message that there was no application to depart from the usual order for costs.
But even then, you admit that, or you accept that that isn't mandatory, and that the court may or may not attach great weight to that particular factor.
Which factor?
That a particular application wasn't made, nor did the judge specifically invite submissions, assuming that to be the case.
Well, Lord, what it does, my Lord, is it reinforces the necessity for the practice and procedure outlined by the Court of Appeal in Trinidad and Tobago, that if you're going to depart from the usual order, as in circumstances where you're going to make an order that neither party invited the court to make, therefore, sure, you should then, give the parties an opportunity to address the court on it. For example, what if the defendant said, well, we think you should stick with the usual order? I mean, but therefore, in those circumstances, it reinforces the need to comply with that procedure. And I can take, and I think that's enough of the contention, really. If the defendants did not apply for indemnity costs or assessed costs, or to take it outside of the general rule of prescribed costs, then what the judge was about to do was a fairly radical departure, and she ought to have given the parties an opportunity to be heard and to give a properly reasoned judgment for it. If we allow, sorry,
go on.
If we go back to the good old days of saying costs are in the discretion of the trial judge, we would eliminate and reverse all the gains that we've made, but with the new rules, whereby we try to put on a consistent, a clear and predictable footing the issue of costs. And then judges are going to create exceptions, whether it's a case where you allege fraud, honestly or fraudulently, and then you're going to go back to square one, where judges are going to just, exceptions will seep back into the law and lead to the very uncertainty that these rules were designed to reverse. And that's the problem.
Mr. Ramlal, would you accept that the bringing of a dishonest and fraudulent claim is a form of abuse of process?
Well, yes.
Abuse of the process of the court.
I can accept that, yes.
And would you accept that if that's right, then the court itself, in the person of the judge, has, if you like, an interest or a duty to seek to protect the court from that sort of abuse, which may incline the court to make orders for costs which the parties haven't asked for?
I accept that, but what I do say is that in such circumstances, the judge has a duty to indicate that to the parties and invite submissions on it.
Yes.
And also then give a reasoned judgment to say why they've made that order. I mean, that's what I see.
Yes.
I'm not seeking to relinquish a residual discretion.
No, I'm just, as it were, drilling in a bit to your submission that
yes.
None of this really gets off the ground unless the party that wants a special order makes an application.
No, fair enough. The point is taken, my Lord. I accept that. So, my Lord, if I may just move on to some of the points made by my learned friend. My Lord, I don't accept at all that the registrar, as suggested by my learned friend, can decide the costs to be paid on an indemnity basis. That's a matter for the judge making the order.
You've already made that.
Yes.
Yeah.
And I also want to make the point, my Lord, that the whole basis on the practice direction and other things on the issue of costs is to compensate for the work done. Now, you can have orders that are punitive in nature, like for example, indemnity cost orders. You can do, but my lord, the object of the rule, the cost provisions in our rules, really aimed at reasonable costs, reasonably incurred, and proportionality. And to that extent, my lord, it is a radical departure out with the rules to make an order that is outside of what the rules permitted in this case. I say that. My lord, the Elahi case I just took you to, judges can in fact and do assess costs. And that case, for example, the budgeted cost, the Elahi case, was a case where a judge was dealing with a pre-trial procedural application, that is an application for a cost budget. So the judge has a discretion because he can assess the costs in a case like that. So therefore, it is in that regard, when if I take you to page 635, to something my learned friend took you to.
65?
635.
635, thank you.
Yeah, sorry. I think it would have been my Lord Burrows who alighted upon this, that at the basis of the quantification at 67.2, where the court has any discretion as to the amount of costs to be allowed. Now, there's a distinction to be drawn with where the court is assessing the costs or quantifying the costs, and that is the amount of costs to be allowed to a party. And the separate question of liability for costs and who should pay. And if I take you to page 636, at 67.3, what the Court of Appeal has been saying is immediately beneath that is the ways in which the costs are to be quantified. So the rules have not left it to chance. The ways in which the costs are to be quantified, and they've given us the options. So the rules it's a comprehensive and detailed code. After a painstaking amount of consultation and discussion, with the Rules Committee in Trinidad, that came up with this. So when we refer to 67.2 with the basis of the quantification, that deals with where the judge has a discretion and he's dealing with assessing the costs that he would wish to sort of award in a particular procedural application as a case may be. Now,
Mr. Roanoke, if you look at 67.3B3,
67.3
B3, which I think is on 637.
Okay, 1 second, my lord.
The very end of 67.3, which starts on 636.
Yes.
It contemplates it being done by assessment where neither prescribed nor budgeted costs are applicable. Now, I'm assuming that if you get to the end of a trial and nobody's got a cost budgeting order, then budgeted costs won't be applicable. You can't do it at that stage because budgeting is a form of doing it up front. The rules don't, as far as I've found, give you any guidance as to when prescribed costs are not applicable, unless that's a matter which the judge simply has to decide, having regard to everything that's happened up until the point when he or she is deciding the question of costs.
Lord, the way I look at it is this: the rules do provide that guidance, and what it says is prescribed costs is the general rule. And if
but accepting that it's the general rule, this rule contemplates there may be circumstances where that general rule is not applicable, but it doesn't lay down, as it were, any code or set of principles or rules to enable a judge to decide when it's not applicable. It's just left to the judge, isn't it?
Well, it is, but you see, it speaks to where neither prescribed nor budgeted costs are applicable.
Yes.
And there is a judgment from the Court of Appeal, Nizam Mohammed and the Attorney General. And what the court has said, my lord, is that assessed costs with respect to that part applies to Part 56 matters, that is, claims to judicial review and constitutional cases, so that you do have assessed costs, but in a particular type of matter, and that's covered by Part 56 matters. But I don't think that this rule here is intended to suggest that a judge has a general pre-CPR old rules type discretion as to costs, whereby the judge has an option to decide, I'm going to award costs either on a prescribed basis, on an assessed basis, on an indemnity basis, and I can decide by reference to my own determination which basis I award costs. That's not how
I mean, you have, I think, accepted earlier in response to questions from my friends that you're not going so far as to say that a judge in a case of this kind, and we're not here talking about judicial review or constitutional claims, you're not going so far as to say a judge can never order an assessment of costs, and indeed can never order an assessment of costs on the indemnity basis.
No, I have not.
If a judge can do that, doesn't the judge have to go through this hurdle and decide that to get to assessment, you have, by some process or other, to decide that neither prescribed nor budgeted costs are applicable?
Applicable or, well, is it applicable or relevant or appropriate?
I'm just looking at the rule.
Sure, my lord, yes.
As you say, this is quite a prescriptive rule.
It is. You see, my lord, my issue is with the use of the word applicable.
Well, that's what the rule says.
Well, fine, but if that is what it says, then it is applicable, because the prescribed cost regime, it is applicable because there was no application to take it outside of that, and therefore the prescribed cost regime is applicable. And if you intend to disapply it because there is some residual discretion that you wish to exercise, we come back to the procedure.
You say there should be a hearing and there should be...
You see, my lord, the problem here is this, my lord. It's taken us a long while to get to this stage in Trinidad. And that's why when you read the Court of Appeal judgments, the more we open the back door to exceptions, given the way the rule is framed as to whether it is applicable, then the greater the danger and the risk of going back to a position where the predetermined predictability and certainty for costs, which was the whole point of the rules, could be undermined, my lord. Of course, and that's why they use the word, is it applicable? It's applicable because there was no application for a cost budget, no application to determine a higher value of the claim, and therefore the prescribed regime is applicable. That's what the Elahi case says, and you're stuck. And to use the language of the judgment, you're stuck with it. And that's the short point. Now,
and what do you say about the two cases that we were referred to by your opponent, where the judges themselves seem to be saying that these new civil procedure rules have to be seen against the general discretions of the court, and there must be flexibility and that sort of statement? It doesn't sound as if they're so wedded to this very rigid approach that you're advocating. These are the judges in the Trinidad Court of Appeal.
I don't think that that's a correct interpretation when one reads what was cited to you in the context of the judgment. Let's take, for example, at page 799, which is what was cited to the court. At paragraph 65, it was the discussion here comes under the heading budgeted costs and the overriding objective. That's the first point. You'll see that above paragraph 63. So what the context in which a statement is made is in the context of budgeted costs. And then what the court says at 65 is the concept of proportionality is a critical feature of the overriding objective. It is therefore not appropriate to consider whether any further guidance is provided by the rules themselves in exercising this discretion.
Well, it's the last sentence that seems to be particularly used against you.
To the extent that it is noted that the court, in exercising its wide discretion in determining who would be liable to bear costs.
Don't place too much emphasis on that, because it then comes to in what amount.
No. I hear you. But you see, and what amount does so against the backdrop of, but you see, it says it does so against the backdrop of part 66 and 67. So that's the template. Part 66 and 67 is the template for it. And then, when you go back to that, it again takes you to a rather Procrustean approach, whereby you're straddled onto the various options that the rules provide. So that is the way that is the way I would look at it. Now, so, my Lord, what we say in closing is this. This is a case where the order for costs was plainly wrong. It was not an order open to the judge to make, we say, based on a proper application of the rules, because the prescribed costs regime bit. And if the judge, without being invited to do so, wanted to remove herself from, unshackle herself from the prescribed cost regime to make a different order, then the judge was duty-bound to follow the procedure in Trinidad and to indicate as much to the parties and give them an opportunity to be heard, and as well produce a judgment that would have give a reasoned decision for that departure. Failing which, we say the order for costs should not be allowed to stand, and that the order should be, as provided for by the rules, that the prescribed cost regime applies.
That you submit as an error of law.
And we say that's a serious error of law, because it's established by the cases that if a litigant sits idly by, because you can flip the script, they also know, they knew that a fraud case was being brought against them, and they would have known it was, as far as their instructions go, that this is a fraud case that's been fraudulently alleged against them. And they ought to have made avail themselves of the options open to them under the rules to take this, to give the judge and themselves the flexibility they desired.
But isn't the consequence, if you're right, that the court should quash the order made because it wasn't made pursuant to a fair procedure? That's your argument, because submissions weren't invited, proper reasons weren't given, and then substitute whatever the appropriate order is for costs after having heard argument.
But that or remitted, yes, that's correct, my Lord. Yes.
That would, if you were otherwise correct, fall upon the board to do.
Yes, certainly. Yes. I mean, my Lord, I say that we say that the correct thing to do would be to, apply the relevant rule and let the order be that the cost be assessed on a prescribed basis.
But if the board went down that road and decided that it ought to do the matter afresh, you're not saying, are you, that we haven't heard sufficient submissions about the merits of what court order should be made? Or that we have no jurisdiction, for example, to make an indemnity cost order?
No, I'm not saying that. But what I am saying, my Lord, is that what the board, what my submission respectfully is, that the position is that if they did not avail themselves of any of the options provided for by the rules to take it outside of the prescribed cost regime, the board should simply say that the prescribed cost regime bites.
Yes.
And to use the language of the Ilahi case, you're stuck with it. Because that is what has been happening. And, my Lord, if the board says otherwise, well, of course, my Lord, I'm not submitting that the board would not have the jurisdiction or discretion to say it.
Or that we haven't heard sufficient submissions about it.
Well, my Lord, we've certainly taken up a lot of your Lord's time on a cost appeal, so I've troubled you enough.
There's just one matter more that I'd like to put to you, if I may, and that's this, that when the matter came before the Court of Appeal, it may be said the Court of Appeal were aware of all the matters which you're submitting to us, and they declined, in the exercise of their discretion, to allow your clients to amend their notice of appeal to raise these points at all, no doubt having in mind the strength of the submissions made by both sides in relation to these issues. And so it may be said that at this stage, it's not a question of us considering the merit of the decision by the judge to proceed as she did, but rather whether it's appropriate for us to interfere with the exercise by the discretion of the Court of Appeal not to allow you to amend your ground of appeal at that late stage.
Well, so even accept that, my Lord, to the extent that the Court of Appeal approached it from through the lens of jurisdiction, to say, well, look, we can't consider it because you didn't get leave. That's wrong. That is also an error of law, because as I've showed you, under the Supreme Court of Judicature Act and the CPR and all of the authorities, the court could have granted leave, and the court could have considered it, even if it's not a ground of appeal. And to that extent, the Court of Appeal erred in not considering the alternative position, i.e., notwithstanding the fact that it wasn't a ground of appeal, that they could have considered it themselves. They had the jurisdiction to do so, but they limited themselves and fettered their jurisdiction by saying, well, look, you didn't get leave, and therefore that somehow deprives us of the ability to consider it, which was wrong in law. But look, I'm sorry, but I've troubled you enough on an appeal that I thought would last a lot shorter and we'll finish before lunch. Whilst I've enjoyed the discussion, I think I've tested my Lord's patience.
Well, we're most grateful. Thank you.
Thank you very much.
The board is indeed grateful to both sides and counsel and those who've been involved in the... I can see a hand up from Ms. Hayes-Suhon. Did you want to say something?
Yes, please, my lords. Just insofar as my lords had asked whether there's any authority that I could put my hands on with respect to the courts in Trinidad and Tobago exercising its discretion not to grant prescribed costs but assessed. I have just found a case which I have forwarded to my learned senior as well as to the court's registry. It's CV 2007-00485, Disha Moranjani. And I just draw to the board's attention paragraph 99, where Justice Rajnath Lee, as she then was, said, in all the circumstances of the case, therefore, the court finds that the second defendant is entitled to the relief claimed in the counterclaim. As to the issue of cost, the court's discretion, this is not an appropriate case to order prescribed cost. And the judge went on to say that according to CPR Part 67.5, the award of prescribed cost is a general rule only. And having regard to the complexity of the issues, the fact that the cost of the injunction have to be assessed, and so forth, the court awarded assessed costs. So just insofar as the board requested my assistance in that regard, I have submitted this High Court decision, which is dated 28th of September 2009.
Well, you'll send that to our registrar, presumably, as soon as you can.
I have already sent it via email, my lords.
Thank you. Thank you.
Presumably, if they want to answer
yes,
it.
Mr. Ramrogan,
Yes.
We'll obviously look at that authority.
My Lord, yes, I'll have a look at it.
If you could do the same, what I'd ask you to do is if there's anything you want to say about it, to do so with brevity and celerity, and let us have your comments on it, if any, not later than the end of this week.
Brevity has not been our hallmark today, but I assure you, I'll endeavour to accomplish that in writing. Thank you.
Well, I was in the process of thanking the parties for their submissions and the hard work that went into them. The board will take time to consider its judgment.
Deeply obliged.